Good afternoon, Your Honours. This is case number IT 0039T, the prosecutor versus Momčilo Krajčnik.
This trial chamber is sitting today to deliver its judgment in the case of the prosecution versus Momčilo Krajčnik.
Mr. Krajčnik is a role model of how a case should not be handled. Every single aspect of Krajčnik was wrong.
Mr. Krajčnik stood trial for one count of genocide, one count of complicity in genocide, and 5 counts of crimes against humanity.
It's an example of the worst of international criminal justice.
Mr. Krajčnik, would you please stand? The chamber finds you guilty on the following counts: persecution as a crime against humanity, extermination as a crime against humanity, murder as a crime against humanity, deportation as a crime against humanity, forced transfer as an inhumane act as a crime against humanity.
Ja u ovom trenutku zaista ne mogu da komentarišem da li je gospodin Krajčnik kriv ili nije kriv, pošto nismo bili u situaciji da kroz fair suđenje utvrdimo činjenice.
For your role in these crimes, we sentence you, Mr. Krajčnik, to a single sentence of 27 years of imprisonment.
I don't think any other trial is going to ever have quite the difficulties that the Krajčnik trial had. The biggest flaw in the Krajčnik trial was that the trial was simply driven too hard, too fast. It just was.
I will say, Your Honour, that I personally, and I'm speaking personally now, have every reason to feel misled and up to a point cheated by this institution. And I will make that strong assertion good.
Dobro veče.
Ovo je dnevnik televizije Republike Srpske.
Momčilo Krajčnik sproveden u Hag.
Jutro su 3 časa i 17 minuta u porodičnoj kući na Palama na osnovu tajne optužnice SFOR je uhapsio Momčila Krajčnika, bivšeg predsjednika Narodne skupštine Republike Srpske i bivšeg člana predsjedništva Bosne i Herzegovine.
Momčilo Krajčnik je 2000. godine uhapšen i prebačen u Hag, u pritvorsku jedinicu Ujedinjenih nacija. A njegova predpretresna faza je trajala 4 godine, do 2004. godine. Tokom tog perioda imao je advokata iz Njujorka koji se zvao Dejan Brašić.
Dan časni sude, ja sam advokat Goran Nešković, sa mnom je ovdje gospodin Dejan Ranko Brašić.
I think Mr. Krajčnik's fate was really sealed when he got that first lawyer.
At that time, Mr. Brašić fulfilled all the qualification requirements for being placed on the list of counsel and to be assigned to an indigent accused. This is the reason why he was on the list then. Clearly, he's not on the list now for reasons which are well known to you.
That is a matter of hot debate, Your Honor, which is ongoing.
This counsel, who's a US attorney, was suspended by the New York bar from practice for offences, professional offences. We don't need to go into the detail of that.
I think it was the 3rd or 4th time that he had been criticized by the Bar Association for taking funds and not doing the work that was necessary or appropriate.
Do you have any idea on what has been spent on the defense?
I would estimate, Your Honor, and I haven't seen any hard figures, but on a case of this magnitude, which has now lasted over 3 years.
No, I'm just asking you whether you know how much.
Somewhere around $900,000 to $1 million.
Yes, add 50% and you might be closer to the outcome.
To je čovjek koji je imao hrabrosti da kaže sudskom veću da je sav rezultat njegovog rada od 3 godine kada je potrošio oko $1,5 miliona za svoju pripremu, da je zaključeno u njegovoj glavi.
Most of the preparation that I had done is unfortunately locked in my brain, and I can't download the knowledge that I have into his brain as from one computer hard drive to another.
Any lawyer like Mr. Brasic who claims that their work product is in the head is basically lying. They're telling bullshit because it means they haven't had any work product. Because even to prepare a trial, you have to write down some notes, you have to make some things. Otherwise, you yourself can't even remember how to do the job when it comes time to do it. So I don't believe in that at all.
Mr. Krajisnik, I want to stress that you are not responsible for the conduct of lead counsel in this case. It's not your fault, it's not your mistake, but nevertheless you're confronted with the consequences of it.
So Mr. Krajisnik was really stripped of his lead counsel just a few weeks before the trial. So clearly the trial couldn't go ahead at that time. It had to be postponed. He had to get a new counsel, which turned out to be me.
Sam advokat Nikola Stewart nije, da kažem, imao nikakve koristi od te 3 godine rada ili nerada Dejana Brašića i nije mogao da se spremi za početak suđenja.
Everything had been ready for trial, but of course we weren't, because I had a co-counsel from Australia as well. We naturally weren't ready for trial. We needed time. We were pushed and pushed. In the end, we started the trial, I think it was the very beginning of February.
We did have to start this trial on the 3rd of February when we were really not ready.
At that time, this case was by far the most expensive case ever heard before the tribunal. I can hardly believe that this amount of preparation or the corresponding amount of preparation would have been completely lost.
I'm not gratuitously out to attack Mr. Brasić, but the fact is that nowhere near enough proper work had been done, and the state of the papers that we received, it was a complete shambles.
There are tens and tens and tens and tens of thousands of pages of documents, and I haven't read many of them. I don't even know what they are. I don't have enough BCS resources to find out what they are. I open a CD and I find thousands of files without any real way of picking my way through them. It is absolutely impossible.
We have not identified our defence experts. We have not had adequate time to interview witnesses as counsel in the former Yugoslavia. We, the defence team, are not across the documents. It's as simple as that.
We have lists of to-do lists. And Mr. Krajisnik is quite fairly always saying, well, what about all these items on the to-do list? And I'm having to say, I can't do them because I've got another to-do list. And I've got to try and do that to-do list before I do the other to-do list.
Nikola Stewart se žalio tih 1.5 godina konstantno sudskom veću da je nespreman, da ne može da unakrsno ispituje svedoke, da mu je potrebno dodatno vreme, tražio je više puta odlaganja i uglavnom je bio njegov zahtev odbijan.
We have examined important witnesses with, in our submission, inadequate grasp.
Every time I read a transcript of this witness that's going to come in Karadzic case and how he was cross-examined at the Krajisnik trial, it almost makes me sick. The judges pushed the defense to the point where even if they wanted to do a competent job, they weren't able to do it.
Here I am, doing things which should have been done in any ordinary case, could, should, and would have been done months and weeks before this trial even started, and we are still doing them.
When experienced counsel are telling the trial chamber and the public that we ourselves are not presenting an effective defence, why would we do that unless it were true?
The trial chamber has adjourned the proceedings for a number of days, and as a matter of fact, when you look at the exact dates of sitting and compare them to the non-sitting days, you'll see that they are almost equal.
This notion of, let's start, and we'll let you do some homework as you're going, just misconceives the whole function of a defense.
And that's happening right now in the Radovan Karadzic case, where they're saying to him essentially, look, all right, you haven't done all your work, we'll start the trial, then we'll give you a delay during cross-examination. You just can't do that. You have to start the trial knowing what your closing argument is going to be. And everything has to work toward the end result of the trial.
Mr. Krajisnik, you may address the chamber just to inform the chamber on the present situation, such as what may have been in your letter or what your present position is. Please proceed, Mr. Krajisnik.
Prvo, zahvaljujem se sudskom vijeću. Gospodo sudije, na početku ja sam rekao da nisam kriv. Ali sam vas rekao, ne tražim od vas da mi vjerujete da nisam kriv, nego da mi omogućite da se utvrdi istina. Ova odbrana to ne može meni pomoći. Ja sam u to uvjeren i pod ovim uslovima i u ovoj situaciji. Vrlo nerado ja sam se odlučio na odluku da se branim sam i da u buduće učestvujem u svom procesu, a ne kao sada periferno.
Mr. President, Your Honors, we are having this discussion quite by surprise to the Office of the Prosecutor. We were informed this morning of this position. We have made considerable arrangements to have witnesses available here. Practically speaking, they're available to testify. They've come from afar to testify. Our position is this. We're not entirely persuaded that Mr. Krajisnik's wish at this point trumps other considerations.
Of course, the Chamber is also surprised by these developments. We'll have to consider the matters, and we'll take some time for that. We'll adjourn for half an hour or more.
All rise. Be able to be.
The international community has entrusted this tribunal with the task of trying persons charged with serious violations of international humanitarian law. The international community expects the tribunal to do so in accordance with the rights of the accused. The fundamental point is that if the tribunal is not given sufficient time and money to do so by the international community, then the tribunal should not attempt to try those persons. This tribunal will not be judged by the number of convictions which it enters, or by the speed with which it concludes the completion strategy which the Security Council has endorsed, but by the fairness of its trials. This case will play a central role in shaping the legacy and the jurisprudence of this tribunal. And without a fair trial, that legacy will be flawed, it will be stained, and it will be a legacy that is not worth having.
Cijela ta nepripremljenost tima odbrane pod vođstvom Nikolasa Stewarta je kulminirala u početkom 2005. godine kada je gospođa Lukas odlučila da napusti predmet jer je smatrala da nije etički da nastavi da reprezentuje gospodina Krajisnika sa tako malim znanjem, odnosno poznavanjem predmeta.
Ms. Lucas had a number of reasons to seek to withdraw, and it is true that one of these reasons was what she perceived to be the pace of the proceedings at that time, but there were also other reasons, some of which are not necessarily in the public domain, and I don't feel comfortable discussing them at this moment.
I was anxious for Mr. Krajisnik that we should do the job properly, but I almost just felt, well, all we can do is our best, and we can only do our best. I think for Chrissa, you know, all we could do was our best, and she just always felt fantastically anxious that that best was so much short of what we might be able to do.
We'll adjourn.
Your Honour, would Your Honour please, with the greatest respect, would Your Honour please just hear the defence on one or two aspects? I will say, Your Honour, that I personally, and I'm speaking personally now, have every reason to feel misled and up to a point cheated by this institution. And I will make that strong assertion good. When we first came into this case, I was told that it was expected that the trial could be ready to begin. It is impossible to understand how that could responsibly and conscientiously have been said to me. I was also told...
Mr. Stewart, Mr. Stewart, may I interrupt you? This sounds not really new to me.
All right, Your Honour, I'll leave that one then. What is perhaps new is that I was also expressly, because I made express inquiries, I was expressly led to believe that the schedule for the trial would provide at least some regular gap during the progress. I was assured that would be so. It hasn't happened. And
Mr. Stewart, I'm going to interrupt you. The matter is not new because it is an aspect of the problem which you have brought to our attention several times.
Your Honours never respond to it, and you haven't responded to what I said the other day, and you didn't respond to what I said before. I constantly raise these matters, and Your Honours constantly ignore them and brush them aside as if they are not part of the real world. You do not show sufficient interest and concern about the position of the defence. You do not inquire properly as to what the matters which are actually affecting the defence, and that has been the position throughout this trial, and the result is that Your Honours constantly impose oppressive and unconscionable burdens with shocking results that we saw during the progress of the last few months of the prosecution case, and with a build-up of undone tasks that this defence team cannot possibly cope with.
Mr. Stewart, this sounds very much as a repetition of what we heard before.
Perhaps Your Honours will listen this time for once, so that I don't have to keep repeating it.
Mr. Stewart, we work on the basis of an assessment of what is needed to prepare this defence. It's not the case that we never grant or that we do not partially grant what you ask for. The Chamber has its own responsibility in judging, in determining what is needed for the preparation of the defence.
The way in which we specifically felt cheated was that we'd really been led to believe that we would be given enough time. That the weight of the case would be properly recognised, and when the trial started, it would go at a pace that would be manageable for us. And we felt, and I feel, that once the case was underway, that was, if you like, conveniently forgotten about.
In the argument we heard from the defence, a lot of attention is paid to what we did not grant. Lesser attention is paid to the flexibility the Chamber has shown.
I don't know if I'd ever want to be in that position under some of the constraints that exist. I know what I would want to do, but I don't know whether the system will allow me to prepare a trial in the proper fashion.
But we would have challenged the system too. We would have said, look, these constraints are too great. We need more time. We need to be able to interview witnesses. We need to go to the former Yugoslavia. We need to be able to make our case the way we make cases, not the way you make cases. We would have handled it very differently, but I'm not criticizing the second lawyer. I'm very critical of the first lawyer.
Nick Stewart never should have taken the Krajina case on in the first place. He should have made sure that the conditions were in place for him to have enough time to prepare the trial when the trial is, before he even takes the appointment.
I'm not convinced that there was a rush to start the trial. In fact, it was counsel, it was lead counsel who said, well, we can go ahead now. So I think we should really defer to the judgment of a professional defense lawyer who says we can proceed with the trial at this moment.
I solemnly declare that I will speak the truth, the whole truth, and nothing but the truth.
Thank you. Mr. Stewart, you may now be seated.
Thank you, Your Honor.
Can you explain to the bench the reasons for the decision not to ask for a delay?
Yeah. Well, Your
and in retrospect, what effect do you think that had on your ability to provide Mr. Krajisnik with a full and adequate defense?
Well, Your Honour, the simple point is that it is just not correct to say I did not seek a delay of the commencement of the trial. I struggled as hard as I could and fought as hard as I could to seek a commencement of the trial. Judge Orry just said to me in one of these meetings, Mr. Stewart, this trial will start on the 3rd of February. And that was it. It will start. It was very clear to me that Judge Orry meant that.
I don't know exactly where the pressure came from, though I can have my thoughts about it, which I will voice. But the presiding judge in the trial was very, very forceful about starting the trial.
We always had the very distinct impression that such questions as when this trial would start had an input and an influence and had pressures from beyond the trial chamber itself. That seemed to us in all our conversations to be transparently obvious.
If we'd been asked, do you want to start this trial? Do you consider you're ready to start the trial? We'd have said no, as Mr. Karadzic is at the moment. We said no, thank you very much. We'd like quite a few more months at the very least to read all this stuff and really get to grips with it.
13 months into the trial, you said your team had only read 15% of the papers. Would you care to answer what percentage of the papers your team had read on the 3rd, 4th of February when the trial began?
Uh, 1%, 2%. I don't, Mr. Nichols. If there were 500,000 papers, we must have read a few thousand, I suppose.
You consider it was proper to commence a trial when your team had only read between 1 and 2% of the papers?
I didn't think it was a good idea, Mr. Nichols, but proper. If I may answer your question. To some extent, this was, if you like, a particular discussion between Chrissa Lucas and me. She'd say, we must go on strike. And I would say, well, actually, Chrissa, we are in a court. And if the court says that the trial starts, we may not like it, we may have protested it, we may fight it, but in the end, if they say the trial starts, the trial starts.
In the light of the event, if we want to classify the assistance that you receive, how do you qualify the better assistance? For example, excellent treatment, special treatment, ordinary fair treatment, or better than average? Would you please give me your preference, if possible?
I'm sorry,
Thank you.
It's me, I'm sure. I'd just like to be clear. Are you asking me to classify the trial chamber's treatment of us in relation to right to fair trial, or are you asking me to assess my own effectiveness as Mr. Krajisnik's counsel, or both?
Peut-être les deux à la fois.
Maybe both.
On a scale, the trial chambers, what the trial chamber offered to Mr. Krajisnik by way of a fair trial, on a scale of 1 to 10, 1 being completely shocking show trial, etc., verdict arranged in advance, to 10 being impeccable, wonderful, absolutely unsullied, immaculate fairness. 3 or 4.
The International Criminal Tribunal for the former Yugoslavia is now in session.
Justice Robert Jackson said of the Nuremberg trials, "We must never forget that the record on which they judge these defendants today is the record on which history will judge us tomorrow." To pass these defendants a poisoned chalice is to put it to our own lips as well. The Brasić scandal, the ensuing ineffective representation of the Stewart team, and the failure of the trial chamber to act effectively in our submission denied Mr. Krajnik a fair trial.
Ja nikada u životu nisam bio veći optimista da će sud ponoviti suđenje, jer sam smatrao da je odbrana iznela neoborive dokaze da suđenje nije bilo fair.
The appeal chamber is not convinced that Counsel Brasic's failure to hand over the case material to Counsel Stewart in a timely and orderly manner resulted in a miscarriage of justice. The appeal chamber finds that the Stewart defense team was not grossly unprepared to commence trial in February 2004. The appeal chamber dismissed assertion that Krajnik's trial was unfair.
Both the trial chamber and the appeals chamber in this case were satisfied, and we're talking about professional judges. A 3-member bench in trial and a 5-member bench on appeal confirmed that the proceedings in this case met the standard of fairness.
I ja zaista i dan danas ne znam koje argumente treba odbrana da iznese kako bi ubedila sudsko, odnosno žalbeno veće, da je proces protiv optuženog lica, kakav je bio gospodin Krajišnik, nefer.
The appeal chamber notes that certain aspects of the conduct of the trial were not free from the facts and may have created an appearance of unfairness. However, the appeal chamber is not satisfied that these defects amount to a miscarriage of justice.
The appeals chamber said a number of things which indicated quite clearly that there were ways in which they felt that the initial trial wasn't actually completely fair. They sort of covered it up a bit in what they said, but it was clear they had that feeling. But it was obvious that they were extremely reluctant to order a new trial.
The appeal chamber is not obliged, having identified an error, to remit the case for retrial. An order for retrial is an exceptional measure to which resort must necessarily be limited.
Both the trial and the appeals chamber have delivered their judgments in the Krajisnik case. In these judgments, they have dealt with a number of procedural issues, in addition, of course, to the factual issues that were part of the case. So as the spokesperson for the prosecution, I cannot go into details in terms of expressing an opinion on these decisions. But this is to say that the arguments of the defense have been addressed in these judgments.
While Krajisnik's convictions for 3 counts of the indictment remain intact, the trial chamber erroneously imputed criminal liability to Krajisnik for 2 other counts and most of the crimes mentioned in parts 4 and 5 of the trial judgment.
The way I read it is, because they weren't willing to order a new trial, they did feel that they should make some reasonably worthwhile reduction to Mr. Krajisnik's sentence.
The appeal chamber notes that the convictions for the majority of the crimes of which Krajisnik had been found guilty have been quashed. However, convictions for persecution, deportation, and forcible transfer have been upheld. Mr. Krajisnik, will you please rise? Here's the disposition. For the foregoing reasons, the Appeals Chamber sentences Krajisnik to 20 years imprisonment to run as of this day, subject to credit being given under Rule 101C and Rule 107 of the rules for the period that Krajisnik has already spent in detention since his arrest on 3 April 2000.
Well, the Krajisnik appeal decision upheld the trial chamber's decision and said that what had gone on in Krajisnik's trial was okay. But they also at the same time gave Krajisnik a discount for having a bad lawyer. I don't think that's really justice to give a discount in the sentence for an unfair trial. Either the trial was fair or it wasn't fair. And I think that it was the problem of having to try Krajisnik's case all over again that the appeals chamber came to some kind of compromise.
I mean, something which has been with us in the tribunal, I mean, those of us working at this tribunal over the last few years, it's been with everybody, hovering around all the time, is what's called the completion strategy.
The completion strategy in and of itself is necessary simply because this tribunal was established as an ad hoc institution. It was never meant to exist permanently, and there was a time when it was determined that the tribunal must conclude its work.
The problem with the completion strategy is that it does seem, and I think it's naive to suppose that it doesn't, it does seem to drive a number of the decisions. And then it's impossible for somebody in Mr. Krajisnik's position, as he was, not to feel that that is having some sort of impact on his trial, which is depriving him of some opportunity to have a fair time to prepare. I think that's not only a natural feeling, but I rather think there is some justification for that feeling as well.
The prosecution has the burden of proof. The prosecution has to describe the entire sequence of events, has to describe and has to prove all the crimes that it charges in the indictment and the responsibility of the accused. The defense doesn't have anything remotely close to that duty. Their duty is to bring into question the evidence of the prosecution.
Nikada odbrana nijednog tima, nijednog klijenta neće imati iste resurse, isto vreme kao što to ima tužilaštvo. Mi se trudimo da smanjimo taj jaz koji postoji između tužilaštva i odbrane što je više moguće.
It's always a balance between conducting efficient proceedings, which is also in the interest of the accused as it is in the interest of the institution as such. There's a fine balance between that and unfairness, and I do not believe that that balance has been violated.
A confidential letter, which was exposed by the Danish newspaper BT, reveals that political influence might be skewing the decisions of the International Criminal Tribunal of the former Yugoslavia in Hague, the ICTY.
Politika je jedna pojava koja je duboko involvirana u sve elemente života. Politika je dovela do sukoba. Politika je izazvala taj građanski rat. Osnivanje Haškog tribunala, odnosno Međunarodnog krivičnog suda za bivšu Jugoslaviju, je također bila stvar politike.
The tribunal was established by the United Nations, which is a political body, if you will. And a number of the accused have been political leaders. But that in and of itself does not mean that the tribunal functions in any way as a political body.
Thank you very much, Mr. President. Today we
the setting up of this tribunal in the first place was driven by politics. But actually, in a way, there's nothing wrong with that. After all, you would expect that. The critically important thing is that the judges actually dealing with the trials don't let themselves be pressured by that.
I u trenutku kad je on osnivan, pojedini stručnjaci međunarodnog krivičnog prava su upozoravali da je Haški tribunal napravljen da bi se verifikovala politika određenih velikih sila na prostoru Balkana. Da bi ona dobila formu sudskih odluka. Da je to jedna najlakša konvalidacija onog faktičkog stanja do koga se došlo ratom. Mnogi nisu verovali, nažalost, kako vreme ide, sve više ih veruje da je to tako.
I think there's very little room for suggestion that any of this is guided by political considerations simply because I believe that all it takes is for somebody to read any one of the tribunal's judgments to realize that that is not the case.
In the cases that I've done myself at these tribunals, both in Rwanda and former Yugoslavia, I started out just trying to do my job very narrowly, to look at the evidence against my client, to see how it's being proven, to defend him within the confines of the case against him. But I found that I wasn't doing my job because what I really needed to also understand is the political context in which these cases were operating, because the judges and the other parties were operating in that context. So I learned a lesson, really, that to defend someone at these tribunals, you have to not only be aware of the law, but you have to be aware of the politics also, and that's unfortunate.
Look, the people who lost 7,000 relatives in Srebrenica, for them, it wouldn't even be satisfactory if he was taken out and hanged.
Viele Serben aus Sarajevo, geschätzte Zahl 140.000, zieht es hierher. Denn sie sehen der Teilung Sarajevos in einer...
Let's be very frank. Terrible, terrible, terrible things happened in many parts of the former Yugoslavia. And there should be criminal prosecution for some of the things that happened. The question is, under what kinds of laws and under what kinds of theories?
Malić hat beim Massaker von Srebrenica 32 Familienmitglieder verloren. Sie kann es nicht fassen, dass Jelačić heute einfach...
Suđenja u tribunalu zaista moraju da budu fair. Svi zainteresovani se nikad neće suočiti sa istinom ili sa događajima koji su se desili dok god ne budu sami počeli da veruju u procese koji se ovdje odvijaju. Ukoliko ti ljudi ne budu poverovali da su ovdje procesi fair i ukoliko ne budu poverovali da se ovdje zaista došlo do istine, zauvek će ostati te tenzije među narodima i zauvek će se kriviti međusobno. Fair suđenje omogućuje i veru u samu presudu tribunala i veru u neku svetlju budućnost međunarodne pravde.
One of the problems that has to be faced about the ICTY is the fact that it has always been intended to have a limited life.
The answer to the future of international criminal justice is not in regional courts, it's not in special courts, it's in a permanent international court.
And it is the last defense, the last opportunity of arriving at the truth, and we can arrive at...
The recommendation to create a permanent international criminal court is old. It stems all the way back from 1948, but no movement happened for almost 50 years until this tribunal was established, until this tribunal demonstrated that an international court of law can in fact function.
As a real exercise in running an international criminal tribunal and doing criminal trials, there isn't a substitute for somebody actually doing it and seeing what works and seeing what doesn't work.
It is undisputable that the contribution that the ICTY has made to the development of international humanitarian law, international criminal law, and procedure is really groundbreaking and phenomenal, I would say.
People are impatient and they expect results immediately. It takes time. It takes time for the roots to kind of settle down in order for the tree to grow.
Ne treba zaboraviti da je međunarodno pravo prilično mlado i da je sve ovo evolucija. I samo Engleskoj je trebalo vekove i vekove da se razvije u demokratsko društvo kako je danas, tako da mislim da i to međunarodno pravo vremenom, ne sada, možda kroz 100, 200, 300 godina će biti u dalekom boljem stanju nego što je danas.
The future of international justice, I think, is really up in the air right now. I would like to see a system whereby there is a permanent international criminal court that stands as a deterrent for tyrants and for other world leaders who think about committing atrocities and committing war crimes, and a system that has credibility by making itself available to prosecute leaders from all countries, small and large, powerful and weak. If we have that kind of system, then I think that really people will have better lives in the future.